Types of quasi-contracts, sections 68 to 72. The Indian Contract Act, 1872 recognizes certain obligations as quasi-contracts under sections 68 to 72. These provisions deal with situations where no agreement exists between the parties, yet the law imposes a duty to compensate in order to prevent unjust enrichment. Each section covers a specific situation, such as supply of necessaries, payment by an interested person, benefit of non-gratuitous acts, responsibility of a finder of goods, and payment made by mistake or under coercion. Thus, sections 68 to 72 explain the different types of quasi-contracts where legal obligations arise by operation of law to ensure fairness and justice. Claim for necessaries supplied to a person incapable of contracting, section 68. According to section 68 of the Indian Contract Act, 1872, if necessaries of life are supplied to a person who is incapable of contracting, such as a minor or a person of unsound mind, the supplier is entitled to be reimbursed from the property of that person. The word necessaries includes things essential for living, such as food, clothing, shelter, medical aid, and education suitable to the person's condition in life. The incapable person is not personally liable, but his property can be used to compensate the supplier. Thus, Section 68 ensures fairness by protecting the supplier while safeguarding the interests of the incapable person. Example: supplying food, clothes, or medicine to a minor. Payment by an interested person, Section 69. According to Section 69 of the Indian Contract Act, 1872, when a person makes a payment on behalf of another person who is legally bound to pay, and the payment is made to protect his own interest, the person making the payment is entitled to be reimbursed. The payer must not be a mere volunteer, he must have a real interest in making the payment. For example, if a tenant pays the landlord's property tax to prevent the property from being auctioned, the tenant can recover the amount from the landlord. Thus, Section 69 prevents unjust enrichment and ensures fairness. Example: a tenant pays the landlord's tax to prevent auction of the property. Obligation of person enjoying benefit of non-gratuitous act, Section 70. According to Section 70 of the Indian Contract Act, 1872, when a person lawfully does something for another person or delivers something to him without intending to do so gratuitously, and the other person enjoys the benefit of that act or thing, the latter is bound to compensate the former. For this section to apply, 3 conditions must be fulfilled: the act must be lawful, it must not be done free of charge, and the benefit must be accepted. For example, if goods are delivered by mistake and the receiver uses them, he must pay for them. Thus, Section 70 ensures that a person who enjoys a benefit must pay for it and prevents unjust enrichment. Example: goods delivered by mistake and used by the receiver. Responsibility of finder of goods, Section 71. According to Section 71 of the Indian Contract Act, 1872, a person who finds goods belonging to another has the same responsibility as a bailee. The finder must take reasonable care of the goods and should not use them for his own benefit. He has the right to take necessary steps to protect the goods and may claim a reward if it was promised by the owner. However, the finder cannot sue the owner for the reward unless it was agreed upon. Thus, Section 71 imposes legal duties on the finder of goods to ensure honesty and fairness. Example: finder of a lost wallet. Payment made by mistake or under coercion, Section 72. According to Section 72 of the Indian Contract Act, 1872, a person who receives money or goods by mistake or under coercion is legally bound to repay or return them. The mistake may be of fact or law, and it is not necessary that the person receiving the money acted dishonestly. For example, if money is paid due to a calculation error or under pressure, the receiver must return it. Thus, Section 72 prevents unjust enrichment and ensures that no person retains a benefit obtained unfairly. Example: excess payment made due to calculation error. Difference between contract and quasi-contract, brief. A contract arises from agreement, while a quasi-contract arises from law. In a contract, consent is essential, but in a quasi-contract, consent is absent. However, both are legally enforceable. A contract is created by the agreement of the parties, where there is an offer, acceptance, lawful consideration, and free consent. In contrast, a quasi-contract is not created by agreement, but is imposed by law to prevent unjust enrichment. In a contract, the obligations arise from the will of the parties, whereas in a quasi-contract, the obligation arises irrespective of the will of the parties. A contract is based on mutual consent, while a quasi-contract is based on the principle of equity, justice, and good conscience. However, both contracts and quasi-contracts are legally enforceable, and the remedies available in quasi-contracts are similar to those available in ordinary contracts. Thus, the main difference lies in the source of obligation, though both aim to ensure justice. Conclusion. Quasi-contracts play an important role in preventing unjust enrichment. Though they are not real contracts, the law treats them as contractual obligations to ensure fairness and justice. Sections 68 to 72 of the Indian Contract Act, 1872 provide protection to persons who suffer loss due to acts of others without any agreement. Understanding quasi-contracts is essential for LLB examinations, especially for problem-based questions.